Welcome to the News Hour. The Supreme Court heard arguments today in a legal case that could vastly expand presidential powers. At stake are 90 years of precedent that have kept presidents from being able to remove members of independent government agencies. The case looks at whether President Trump acted legally in firing Rebecca Slaughter, a Democratic member of the bipartisan Federal Trade Commission, saying her service was inconsistent with Trump administration priorities. Slaughter sued, arguing that commissioners can only be fired for inefficiency, neglect of duty, or malfeasance. Today, Trump administration lawyers argued that gives agencies too much power.
It continues to tempt Congress to erect at the heart of our government a headless fourth branch, insulated from political accountability and democratic control.
But liberal justices warned about the impact this could have on the balance of power.
You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
Some of the biggest power fights in American politics don't look like fights at all. No rallies, no dramatic floor speeches, no constitutional convention, just a firing notice. And lately, that's where a lot of this is happening, in the quiet question of who gets to keep their job when they're supposed to be independent. Because right now, we're watching a coordinated legal push to bring traditionally independent agencies under tighter White House control. And the courts are split over whether the law still allows Congress to put any brakes on a president who wants to fire officials for political reasons. This isn't abstract. It's not process. It's not inside baseball. This is the machinery that decides whether workers can organize, whether whistleblowers have protection, whether consumer fraud gets prosecuted, whether political retaliation inside the federal workforce gets stopped, and whether those decisions can be insulated even slightly from whoever occupies the Oval Office. So today, I want to decode what's happening, how the rhetoric is being used to justify it, and why this fight matters for democracy, even if you've never once said the words administrative law out loud in your life. Here's the short version. Congress created certain agencies and boards to enforce laws, and in some cases, Congress added for-cause firing protections. That means presidents can't remove certain officials just because they don't like them. There has to be a lawful reason, like neglect of duty or malfeasance. The Trump administration is trying to weaken or eliminate those protections through a series of cases, some in lower courts, some in the Supreme Court, some through emergency stays that let removals go forward while the legal questions remain unresolved. And the most recent major pivot point, on December 5th, 2025, the D.C. Circuit ruled Trump may remove Democratic members of the National Labor Relations Board and the Merit Systems Protection Board at will, even though statutes provide for-cause protections. That's not just a procedural ruling. That's an argument about the structure of government, and it could become a template for dismantling independence across a whole category of agencies. This is where the rhetoric gets slippery, because independent agency sounds like some unaccountable fourth branch of government. But what it really means is Congress tried to design certain enforcement functions to be a little less whiplash-prone, not perfect, not immune from politics, not magically neutral, just less vulnerable to the scenario where a president says, "You're investigating my allies, regulating my donors, or protecting workers in ways I don't like, so you're fired." Take the NLRB. It enforces federal labor law for private sector workers. That includes cases about union elections and unfair labor practices. If you can swap out board members whenever you want, enforcement can swing wildly, not because the law changed, but because the personnel changed. Take the MSPB. It protects federal civil servants from political retaliation and handles certain personnel disputes. If that board is fully at will, then the guardrail against purges and retaliation becomes thinner. Not necessarily gone, but thinner. Take the FTC, Consumer Protection and Antitrust. The Supreme Court is currently being asked to decide whether a 90-year-old precedent that protected the FTC's structure should be curtailed or overturned. And take the Office of Special Counsel, the whistleblower protection and anti-retaliation watchdog, which has already been caught up in an emergency docket fight over its head, Hampton Dellinger. So when people say, this is just about a firing, What they really mean is, this is just about whether the president gets full control over enforcement. And that's not just anything. The core constitutional question is simple to say and hard to settle. Can Congress limit a president's ability to fire certain officials? Or does the Constitution require at-will removal because the president is the head of the executive branch? There's a long-running tension here. On one side, the argument that a president must be able to control executive power because otherwise you get unaccountable government. On the other side, the argument that Congress is allowed to design agencies in ways that prevent abuse, corruption, and politicized enforcement because otherwise you get executive power concentrated so tightly that it becomes something else. And this isn't theoretical. The research package is explicit. The administration's argument is that agency insulation creates a constitutionally suspect fourth branch and prevents presidential accountability. So what precedents are they fighting over? Humphrey's executor, 1935, upheld for cause protections for multi-member commissions like the FTC. Sela Law, 2020, struck down for cause protections for a single director agency, CFPB, narrowing but not fully overruling Humphreys for multi-member commissions. Collins v. Yellen, 2021, another modern case about removal restrictions and remedies, often cited in these disputes. And then there's a procedural weapon that matters a lot, the emergency docket, where the court can allow removals to proceed while merits questions are still unresolved. That matters because if you can remove someone now and litigate later, the practical reality changes even before the final ruling does. The D.C. Circuit's December 5th ruling is important because it's described as a move toward a merits holding, not just preliminary injunction jockeying. The panel concluded Congress cannot restrict the president's ability to remove NLRB and MSPB members because those bodies exercise significant executive power. Translated into normal language, the more an agency does real-world enforcement, the harder it becomes to justify protecting its leaders from at-will removal. And if that logic spreads, it doesn't stop with those two boards. Because if significant executive power becomes the trigger, then most independent agencies will be vulnerable. Here's the rhetorical move that shows up again and again. Unelected bureaucrats are overruling the will of the people. It sounds like populism. It feels like democracy. It comes wrapped in the language of accountability. But it often functions like something else, a permission slip to remove legal constraints on executive power, because the people who lead these agencies were never meant to be elected in the first place. They were meant to enforce laws that elected lawmakers passed. So the real conflict is not voters versus bureaucrats. The conflict is, I was elected versus the law still applies. That's the collision point. And if you think about it, that's exactly where democracies usually get into trouble. When elections are treated like a blank check to control everything, including enforcement, rather than a grant of authority inside a legal system. A president isn't a king with a popularity contest. A president is an officer in a constitutional framework with constraints that exist precisely because human beings, when handed power, tend to not voluntarily give it back. So when you hear unelected bureaucrats, listen for the subtext. Are they talking about policy disagreement? Or are they trying to remove the people whose job is to say no? Because a lot of these agencies are, in practice, places where no can still happen. Let's bring this down from the constitutional cloud layer. NLRB and MSPB are not abstract bureaucracy. They affect whether workers can organize, challenge retaliation, and get remedies. And if you can replace agency officials for political reasons, you increase the risk of enforcement whiplash, politicized administration, the sense that outcomes depend on loyalty, not law. Here's the part that's hard to say out loud, but matters. When government becomes openly personnel-driven, when rules are treated as optional depending on who's in charge, people lose faith that the system will protect them when it counts. Workers stop filing complaints. Whistleblowers stop reporting. Civil servants keep their heads down, not because they're lazy or apathetic, but because the cost of standing up becomes too high. That's not just bad governance. That's a civic injury. And it hits the people with the least power first. The worker without a union, the employee facing retaliation, the consumer who got scammed, the civil servant who won't play ball. If the DC Circuit ruling is the latest pivot, the FTC case is the big swing. A DC district judge ruled Trump's firing of FTC Commissioner Rebecca Kelly Slaughter unlawful under the FTC Act and ordered reinstatement, July 2025. The Supreme Court later allowed Trump to remove her for now and agreed to decide the broader scope of removal power, September 2025, with Justice Kagan dissenting. The Supreme Court set December 8, 2025 for merits arguments. And the stakes aren't just FTC drama. It's whether a long-standing legal architecture, basically the idea that Congress can create independent commissions, still exists in the form most Americans have lived under for decades. This is where I want to slow down, because this debate is often described as accountability versus bureaucracy, and I get why that's appealing. I really do. People are tired, systems feel slow, institutions can be frustrating, agencies can be captured, incompetent, or overly cozy with industry. All true. But the question is, accountability to whom? Because there's a version of accountability that means rules are enforced consistently, investigations are insulated from personal retaliation. The law outlasts one election cycle, and there's a different version of accountability that means enforcement is loyal to the president, regulators are removable on demand, independent checks become dependent survival instincts. And if you're thinking, well, isn't the president supposed to be in charge of the executive branch? Yes. But our system has always been a tug of war between energy in the executive and guardrails against abuse. The founders feared concentrated power. Congress feared it too. And over time, the country created structures that tried to manage the risk. Independent agencies were one of those imperfect, highly American compromises. We want enforcement, but we don't want it fully weaponized. So when a president argues that all executive enforcement must be directly removable at will, the question isn't just legal, it's democratic. Because if enforcement becomes personal, political, and removable, then rights become conditional. And once rights become conditional, they're not rights, they're privileges. That's a line I don't say lightly. This is not one case, it's an escalating campaign, with emergency motions and litigation converging toward a larger restructuring. So what should we watch? 1. Whether the Supreme Court substantially narrows or overrules Humphrey's executor, and how broadly it writes its reasoning. 2. Whether more agencies get targeted immediately if that precedent shifts. 3. The practical policy effects, which will depend on who gets installed and how aggressively enforcement priorities change. And here's the uncomfortable but important part. These outcomes won't just matter under Trump. If the court hands presidents of either party broader removal power, it will change how the executive branch functions permanently. That's why this topic matters, even if your politics aren't progressive, and even if you're not particularly emotional about the FTC. It's a structural change to how power is held and how quickly it can be turned.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.